by way of introduction, before I start, go to the March 2023 papers, conveyancing. If you want to pass conveyancing, the secret is that you must know the interest in land. Every time you are looking at the question, you must first of all ask yourself, what is the interest of the land? That is what the question is testing. That is number one. Then, and generally, these are the main interests of lands that usually tested in an exams. Land, is it a freehold? And is it a lease? Community land. Leases, when you ask about tenants and landlord. Then section of properties. Then charges. You see? Then, after you know the interests, those are the main interests in land. The things, the question usually revolve around there. Then, be free to interject anywhere at any given time. Then, you must know, after you know the interest in land, you must know the process involved in registering the interest. You see, for example, if it is land, the process, maybe there's a buyer and a seller. That process from pre-contract until completion. And then you know the duties of the advocates. Then in every process, then you, both for the seller and for the buyer, then either charges, usage, and charges duty. Then the completion documents. Then remedies in case of breach. So if you know all those things, the interest in land, the processes, and completion documents, the document involves, and the remedies in case of breach, you are good to go. So I go now straight to the papers. March 2023 paper. Well, no, October 20. We are going to start with October. Let me share the screen, my screen here. This is October. October 2022 paper. It says that you are sharing the screen. I hope you can see. Now, question number one. Riverine Limited, registered owner of 50 acres of land in Machakos, in close proximity to Nairobi. The company has been facing tough times of late and is seeking to maximize its returns from ownership of property by taking advantage of its location. Currently, question 1A, the land is presently under food crops. The directors of the company have approached by a real estate development company, which would like to construct 25 townhouses to be offered for sale for general public on portion of land measuring 10 acres. The directors are enticed by the idea of this project and have now approached you as their advocates to advise them on the steps necessary for them to enter into a transaction. Express to them the steps needed to ensure the proposed use of land is approved. 5 marks. when you read this question, what are the salient features of this question? You remember the document that we discussed last weekend on doing by exams. What are the salient features of this question that will most likely help you to answer the question? Anyone can try. Marian?
I wasn't there last week, but I feel like the question is asking us for the procedure for change of user from agricultural land now to commercial land.
Okay. Yes, change of user. And every time you see, when you are told about the land is presently under food crops. So this is something, this is the clue that is showing you that this is an agricultural land. Okay. And there is would like to go to townhouses. So townhouses, 25 townhouses. Tells you those are commercial land. So this land must be changed from agricultural land to commercial land, so that they can be able to be able to sell. So it's needed to ensure the proposed use of land. So this, you are right, this is change of user. So change of user, Ruth, how do you go about change of user?
I don't know the whole process, but I know the first thing you do, there has to be advertisement.
Okay.
For the intended, but because this is land, I think National Land Commission has to be involved, but you'll tell us where.
Yeah.
The first thing is you have to advertise. When you advertise, after that, that gives people time to deliberate upon it. Once after the expiration of advertisement has happened, the physical planner comes now is involved, where they reviews the comment and make a report. After that, there is another gazettement. After that, I can't remember.
Okay. Yes, you have tried. You see, for the secret of this thing is you must be able to understand the processes. You know, they usually say that if you look at the first page of the question paper, they are saying the answer must be followed by relevant statutory provisions and case law. So it is very important that you quote the Physical Land Use Planning Act, even if you don't know the exact section. That is going to give you marks. And also in your answer, you must also quote that this change of user is applied through the relevant county executive member for lands of Machakos County. Yeah? And the application is online application through PA1 form. You prepare planning brief proposed development by registered physical planner, copy of documents, comprehensive location plan.
Mwalimu,
yes.
We are writing. I think I'm writing personally.
Okay, I'll go very slow.
You start with the Physical Planning Act.
Yes, so this is a repeated question. Question 2A of November 2021 was testing a candidate on his knowledge of change of user from agricultural land to commercial land. So this is not the first question the time it has been asked. It's a repeated question. You can look at question 2A, November 2021, which you already have. The change of user process is per section 58 to 61. Of the Physical and Land Use Planning Act 2019. And the Physical and Land Use Planning General Development Permissions and Control Regulation 2021. Physical and Land Use Planning into bracket General Development Permission and Control Regulation 2021. The process is as follows. A person shall obtain development permission from respective county executive committee member responsible for land. And in your answer, you must state that this is the Machakos County executive member for land, because this land is agricultural land is in Machakos. In the prescribed form, and the prescribed form is PPA1 form. The following documents should accompany the PPA1 form. A, the planning brief for proposed development by a registered physical planner, which Ruth have said. Planning brief. Then secondly, number B, a copy of ownership document. That is a title. Comprehensive location plan. If I go very fast, you tell me. Survey plan. Civic design or master plan for large projects. Then this person, the change of user or these directors ought to have done an advertisement in the local dailies. I think you have seen in the newspapers change of user. If I could have scanned a change of user, you go to the dailies, you see they so that they attach that advertisement. Then they ought to have put a notice of a board around the land saying they want to change it from agricultural to commercial. So they must also attach that evidence to the CC. I think you have seen that in the plots. Then they must attach evidence of public participation with the neighborhood resident association where applicable. So if there is a residence, people around that area, residence association, there are various residence association. You should have informed them that you want to change the user from agricultural to commercial. So you attach also that evidence. So all those documents are what you needed. So within 7 days of receiving an application, for that, with also those documents attached, the CEC is required to give relevant authorities and agencies to review and comment on the same. These relevant authorities may include, for example, the Ministry of Land, because this is a county government, the Ministry of Lands. Then within 14 days of submitting to the relevant authority like Ministry of Lands, they ought to have to reply to the CEC on their comments. Then within 30 days of receiving receiving the application, permissions from the permission from the Ministry of Lands, the CEC is required to grant the applicant the development permission. Now this is a change of user if there is no objection. So there in the documents that are required, you also should say that you pay the fees. When you submit the documents to the CC, you pay the fees. Then you must know the 7 days timeline for the CC to submit the application to Ministry of Lands. Ministry of Lands have 14 days to reply to the CEC. Then 30 days, from 30 days of getting the reply from the Ministry of Lands, the CEC gives you the change of user. So, and by doing that, you get your 5 marks. I don't think that is a very difficult question. And I think this question was also repeated in October, in the March 2023 paper. So these are very common question, change of user. And change of user and subdivision of land. That's, you may also be asked subdivision of land, where someone wants to sell, okay, it is here, we are going to deal with it. So we go to question B. The land is currently charged to Maribora Bank. The company has received notification of default from bank with notice indicating that if company does not make good the default, the bank will exercise its statutory power of sale without further reference to the company. Advise directors on the bank's statutory power of sale and what can be done to salvage the company's prime property. This is another very common question. Almost all the papers usually you'll be asked on how, when a bank wants to exercise the statutory power of sale. So what do you think this question usually tests? Ruth?
This is about charges, not the power of sale.
Sorry?
It's more of charges.
Yes, yes,
the topic
yes.
on charges, sorry.
Yes, it's topic on charges, eh? It's topic on charges. But this question, what if you have seen, you have looked at the past papers and the answers I usually give, what do you, yes, it's on charges when a bank wants to exercise its statutory power of sale. But what is usually what does the CID usually test in this question? Marianne?
I think it's the procedure, like if the bank, I don't know, if the bank issued notices properly, if the due process was followed, if the chargee was availed opportunity to rectify, I think, I'm not sure.
Yes, you are right. So this is a very common question, and when every time you are asked about statutory power of sale, the question or the theory is usually testing you on the timelines which are found in section 90 of the Land Act, and think also the section 96. So this question is testing the candidate on his or her knowledge of chargee steps, that the steps the chargee is required before exercising a statutory sale if the bank followed them. You see, this question says that the company has received a notification of default from the bank with a notice indicated if the company does not make good the default, the bank will exercise its statutory power of sale without further reference to the company. So this question requires you to discuss the notices that are required under section 90 of Land Act and 96 of Land Act, which now you can write under section 91 of Land Act. Where default, you can look at that section, what it says later. When a default in payment has continued for more than a month, a chargee may issue a statutory notice. This means under section 56(2) of Land Registration Act, the notice will run for 3 months. I repeat, under section 91 of Land Act, when a default in payment has continued for more than a month, the chargee may issue a statutory notice. This means that under section 56(2) of Land Registration Act 2012, the notice will run for 3 months. So that is the first notice they must issue when there is default. Under section 92 of Land Act, the notice served to the charger under section 91 should inform the charger. So that notice that you have been, the charger is being served by the chargee under section 91 should inform the charger the following, which you should state clearly in your exam for you to earn the maximum marks. Inform the charger the nature and extent of the default. If the default is non-payment of money, the amount at which must be paid to rectify the default, and by which time, which payments must be done. So because this is a default, must say you have defaulted paying 500,000. This is the principal amount it was due on this day. So for you to remedy the situation, pay this amount by this time. That notice must contain that. The notice must also contain a very clear statement that if the default is not rectified within the time specified, the chargee will exercise any of its remedies provided by the Act. And here, if you look, the bank, Maribora Bank, is saying that it's going to exercise its statutory power of sale. That is one way the company can do. They can also enter into possession. They can do many other things. Then, Section 93 of Land Act. Still we are under Section 90. Now subsection 3. If the charger does not comply within 90 days after the service of notice, the chargee may sell the charged property.
Please repeat that.
Under section 90 of subsection 3 of Land Act, if the charger now does not comply within 90 days, the 3 months I told you there, of service of the notice, the chargee may sell the charged land. Now, we go now to section, now the chargee want to sell the land. Under section 96(2), before exercising the statutory power of sale, the chargee now must serve another notice. That was the first notice was for 3 months, which you have already talked under section 90, saying all those things we have said there. Now, this is the second one. They serve a chargee a notice to sell, notification to sell, we may call it. To sell in the prescribed form and shall not proceed to complete any contract for sale of charged property until at least 45 days have elapsed since the date of service to sell. So section 96(2), after the 3 months have elapsed, the chargee must have now another notice called the notification of sale of the charged properties, and must also now wait for another 45 days again before they sell. This 45 days still gives the charger a window to still redeem his or her property to save it from being sold. Section 96(3) of Land Act states that a copy of the notice to sell is served in accordance with section 96(2) shall be served in all people mentioned in that section. You can look at it. So section 96(3), you serve the notification to the charger and also to the any other person affected with the sale must also be served. That is section 96(3). And to the person most relevant, there are so many people mentioned there. You can look later at section 96(3). But for purposes of this question, the most person who should be served in this is the guarantor, because of course when you are taking a loan in the bank, there are guarantors. So he must also be served. In other instances, there are questions where you see a man has charged land. So if it is matrimonial property, the spouse must also be served. But for these purposes of this question, because it's a company's land, so the only person which is most relevant is the guarantor. Section 97 states that the chargee must, before exercising statutory power of sale, must make sure the property fetches the best market value. Which of course means that the land must be valued afresh. So in your question, you state all those things. Now you answer your question by saying, we are told that in the question, the bank we're exercising is actually price to sale without further reference to the company, which will be in the violation of the steps which you have said there, given to the company when the bank starts the process of statutory price of sale. Another very, very important, the directors may move to court to stop the sale of property. So this Maribora Bank don't want to follow the process, which we have already talked. So the directors may move to court to stop the sale of the property. And there are so many cases. Have a case law. In each of your questions, have your case law. You are going to make your answers very well. State the law and state the steps and your case law. In this question, there is this case law I took. You can look at it later. In TSS Salt Manufacturers Limited, TSS Salt Manufacturers Limited, TSS Salt Manufacturers Limited versus NIC Bank Limited, 2018 EKR.
Please state.
TSS Salt, Chumvi.
Oh, salt, okay.
Yeah, Manufacturers Limited versus NIC Bank Limited. Okay. NIC Bank Limited, 2018 EKR. Okay, the court granted an injunction to the plaintiff who were about to sell the charged property to restrain the sale of the suit property as proper notices to sell the property and notification of sale had not been issued. So that was the long and short of the case. So you can see this, as I said, these professional exams, you must state the law and the case law, and this is where the students usually get problem. So you must know these processes. And by the way, these are very common questions. So statutory power of sale, these are very common questions. It may come. I can tell you in April, in your exam in November. Change of user, it may also come, very highly likely. And if they are not going to give you change of user, it will be subdivision of land. One of them must come. So have these processes and case law in your fingertips, memorize them. Now we go to question C. Advise the directors on the steps required to effect the transfer on the respective units to buyers in event that the negotiation with the real estate company are successful or protecting the interests of the company. So we are told that these people have 50 acres of land in Machakos. They want to give 10 acres to these people to do townhouses. Now, these people, you are told now the director on the step required to effect a transfer on respective unit to buyers in the event that the negotiation with the real estate company are successful. So if you are in an exam and you ask, and remember these are 10 marks. So this question tells you that it needs you to write a lot. It is testing so many things. So what do you think the question is asking? Nani, you can start with Ruth.
Personally, I would say off-plan and sectional properties, because I don't think they've developed it yet.
Median?
I support, but that my issue would be if we're also supposed to consider the charge in part B. So I feel like that also has to be in consideration.
Okay. Now, advise directors on the step required to effect a transfer of the respective unit to the buyers. What is the meaning of this? The meaning of the word respective unit to the buyers in event that the negotiation with the real estate company are successful. To the buyers, we are told these buyers want to buy measuring 10 acres. Real estate development company would like to construct 25 houses to be offered for sale in general public on portion of land. We are told this company which offer, they want to transfer their respective unit to these buyers. So Riverand Limited want to give Riverand Limited want to real estate development company which would like to construct 25 houses to be offered for sale to the general public on portion of land measuring 10 acres. So there is Riverland, there is the development company, there is 10 acres. Then this development company are going to build the 25 houses on the 10 acre. So if you understand this question, then you go to advise the directors on the steps required to transfer the respective unit to the buyers. In effect, with the negotiation with the real estate companies is successful. So there's directors of Riverland, and also there is this real estate company. So, and there is now the real estate companies are going to develop the 25 townhouses on 10 acres. So there is one transaction between Riverland where there is directors, then there are real estate company which are going to get 10 acres from these 50 acres, which is agricultural land. They get 10 acres. Then from those 10 acres, they are going to develop 25 townhouses to respective buyers. So they are going to subdivide the 10 acres, build the 25 townhouses, then sold to the 25 houses. But this question is asking between the transaction between the directors of this company called Leland and the real estate company. So this question is not testing after the townhouses have been developed. Are we getting the point? Are we together? So you cannot talk about sectional properties because this question is not testing between after the buyers have gotten the 10 acres, now they are developed the townhouses, now they want to sell. They still this land is agricultural land. They want to get 10 acres from 50 acres. This is a company. They want to get a commercial so that they can be able to develop. So this question is, you are supposed to answer this way. The director's duties to call a meeting of the company to approve subdivision, change of user, and transfer of company's land. Remember, in your commercial land, the directors usually act on behalf of the company. So they cannot do the subdivision now to get the 10 acres from 50. They need to involve the members. They cannot also do the change user to get the 10 acres, to change of user from agricultural to commercial. And they cannot use the transfer. So the first step, they need to call a meeting of company according to the laid out procedure and company relevant roles so that they can be given the go ahead because of the fiduciary duty of the directors on behalf of the company. The knowledge that you have for your commercial comes. And these are new questions which have never been tested before. So after calling the company's meeting, the shareholders of this company must give a resolution to subdivide the land into two. The 40 acre, which the company will be left with, and the 10 acres, which will be sold to the real estate company. That is another point. Then they also give a resolution and pass a resolution of change of user of the 10 acres. Remember, the change of user is done by the seller, as we talked in the question 1A above. And also, the transfer of the 10 acres to the new buyer. After it has been subdivided, now they must give a transfer. Now, we start with the subdivision of land. Now we go to the processes. Remember, I told you conveyancing, you must understand the process is very, very important. Subdivision of land from 50 acres so that it can be divided from the 40 acres to be left for the company and 10 acres to sell to these people. Subdivision of land. Can someone try on how the processes on subdivision of land? Ruth?
Let me pass on. I actually wanted, when you were discussing the subdivision, I wanted to ask you if you could give me the procedure.
Okay. Marianne?
What I remember is there's something to do with a cadastral map. Is it the surveyor comes to demarcate the boundaries, then we submit the old title to the registrar, who closes the old registry and opens a new one for the new title, something like that. I don't remember much.
Yes, very good. That is correct, Marianne. So what you need to do is to master this process. You memorize this process before your exams. And for you to get these maximum marks, remember I've told you that conveyancing, you must know the processes very well, step by step. So the first step is the directors will do a title search from Addis as a platform. Remember, these things are done online these days at the SASA platform, not manually. which will tell you the land has, which has land has any restriction that prevent you from subdividing it. So the title Land Search from ArcSasa platform will tell the directors if they have any restrictions that prevent them from subdividing the land. Then the next step, the directors will look for a surveyor to help them get a RIM, registry index map. Which shows the map of the land to be subdivided. You can say there, the cost of surveying will depend on the size of the land. So the surveyor will do. The surveyor then will take the measurement of and set the boundary marks. They will go physically to the land and they are going to separate the 40 acres and the 10 acres. Then the surveyor creates a subdivision plan. Which must be signed by a physical planner. Then, after they do all that, those documents must be taken to the Machakos Lands Office, the relevant land office. And approval is issued on a form called PPA2. That is not very, very important for exams. You can say that the approval is issued by the land office, but you can write PPA2, Physical Planning Act 2, a form, it is called PPA2 form. It's in the under Physical Planning Act, PPA2. Then the next step will be, remember, every time an agricultural land is being divided, the land control board must be involved. That is a very, very important point. If you don't write that in an exam, you are going to fail. Subdivision of property, agricultural land, the land control board must be involved. Change of user, the CC for land, which of course it's once in per month. I don't know if you have ever done that practically, and they usually sit in the deputy county commissioner's office, the DCC. So when you go there and land control board, they usually ask you, why do you want to subdivide the land? They just vet. And of course, at the land control board, they are going to table the resolutions by the shareholders that stated that the company shareholders gave you a go-ahead to subdivide the land. Then The next step, after I've been given the land control board concept, the directors, of course, together with the surveyor, sign the transfer document. The transfer document, of course, will be signed by the directors and the new buyers. To the local survey office, we will assign new plot number. Then the documents, so the two plot number are issued. The documents are then taken to county registry. Of course, this is Machakos County Land Office, which will issue 2 title deeds. One with 40 acres and the other 10 acres. Then finally, you can stop there, but you can also say that the new title registration documents are taken to the Survey of Kenya to office to amend the maps. But that is not very, very important. You can stop at issuing of title deeds, as Marianne said.
Okay. Mwalimu, you said the new title, the last one?
The new title deeds, the new title registration documents are taken to Survey of Kenya to office to amend the maps. The new title registration documents are taken to Survey of Kenya office to amend the maps.
Thank you.
So, you know this question, if you even by reaching there, if you talk about if I was marking the sheet for a candidate in this question, by talking about calling the meeting, resolutions, all those things under this process, very elaborate process, you will have earned yourself more than 5 marks. You have already tackled the question substantively. Then
I have a question.
Yes. Go ahead.
Is the procedure, well, like if the question asks you, I have bought 3 pieces of land and I want one title, for instance, the one where I think amalgamate the land, is the process the same as this one for subdivision, but the vice versa is instead of dividing, now we're putting it together?
Amalgate, to put them together. Yes, the process is almost.
Yes, let's say
the process. The process is just is just the same. The process is the same. Now, but now you are putting the plots together.
Thank you.
But you can the land control board is usually used for subdivision of land. When you are amalgamating, putting them together, you will not need to visit the land control board. And that question of amalgamation has been tested. I'll come back later in our maybe our afternoon question. That's a very good question. I'll come back and talk more about amalgamation. So it is good when each and every after if you are being asked about something, you may also ask yourself, what can they ask in a question? For example, if they are asking you change of user, they can ask you about subdivision of land. If they can ask you about subdivision of land, they can also ask you about putting the pros together. So it's very important that you think outside the box. So the question still, you discuss change of user. You have already discussed in question one above. You don't need to repeat yourself. You can say that the change of user process is as explained in question 1A above. And students usually make a mistake of repeating what they have written above. And there is no time. Never do that. And also, as I told you, if you are asked, if you see that you are answering a question of doing by exam document, if you see you are answering a question again, the same answer for a question that you had already answered, most likely there is something you are getting wrong. An answer cannot be for two sub questions, A and B. So then you are also, the question was steps required to effect the transfer. Now you discuss the process of transferring the 10 acres of land to the buyers. So, remember these two title deeds are in the name of, they are still in the name of the company, and the other 10, the 40-acre land and the 10-acre land. So now you discuss the process of transferring the 10-acre to the buyers of this real estate as follows. This is not a very difficult question. I told you every time where there are processes, also think about the duties of the advocates involved. So you say this, directors will hire a lawyer, the seller's advocate, which are the seller's advocate, to act for them. And the buyer, which is the real estate, will hire their lawyers, which is the buyer's advocate. Then the next step is the pre-contract inquiries and investigation of titles, which of course you know are done by the buyer's advocate. Then, remember, I told you by answering this question, talking about the company resolution and subdivision of land, you have already gotten your 5 marks. Now you are talking about the other 5 marks. So don't make, each 1 point is 1 mark. So you don't put so many things. So the seller's advocate from their conveyancing land prepare the sale agreement and send to the buyer's advocate for approval. That's a very, very important point. You must remember that the sale agreement is always done by the seller's advocate. Then the buyer's advocate will sign the sale agreement and send it with the deposit required in the sale agreement. Then the next step is seller's advocate get all the consent and clearances required to sell the 10-acre plot. And you can say the relevant consent here is the clearance and consent is the rates. Rates from Machakos County government. Then the next step is that the buyer's advocate draft the conveyancing or transfer. Then and pass it to the seller's advocate for approval. Then the completion. This is done at the seller's advocate office. Very, very important. Always remember that the buyer's advocate drafts the transfer. The seller's advocate draft the sale agreement. If you don't say that in an exam, you are not safe. Then, completion. You must say that completion happens at the seller's advocate. And the parties sign the transfer. And the seller's advocate delivers all the completion documents, while the buyers give the balance of the purchase price. So when you are talking about completion, not for this, for purposes of any question you have asked, you must talk, number one, very, very important. It is done at the seller's advocate office. Parties sign the transfer. Sellers delivers all the completion documents. Buyers give the advocate the balance of purchase price. Completion is a very highly examinable area. And the completion documents, you can name them. Marianne, what are the completion documents?
The passport photos, the KRA pin, the original title document, its clearance, if it's a company, the particulars of the directors and the certificate of incorporation. These are the ones I can recall off the top of my head.
Yes. If you are if it is a leasehold, you talk about rent clearance. No. A copy of IDs, you have talked about that. So those are the completion documents. So if you name about 5, you are good to go. So this completion thing is another very high examinable area. So kindly have those things. And if you answer this question by talking about the first of all, the company's resolution, because the directors cannot do anything, because you are being as protecting the interests of the company. The directors are do this thing of fiduciary, or a duty of fiduciary. So you talk about Collins' resolution, and you put all the knowledge you have about commercial. Then you go to subdivision of land, as we have talked. Then after the subdivision is done, you talk about the transfer, as we have talked. You earn your 10 marks. Sawa. You go to the next question. Question number 2. Ahadi and Juhudi come to your chambers for legal advice when they read the following facts. Ahadi owns a 10-acre land. You see, when you are doing your exams, have a sketch somewhere. So if you are doing a sketch, first of all, you are going to say, after you read every fact or given to the question, you write the most important facts. So there you write, Ahadi is the owner of 10-acre land. Juhudi has convinced Ahad to sell him property for 20 million to develop a housing estate comprising of 40 housing units for sale. So Juhudi is the buyer. You write that in your question. 20 million to develop. Every time you see the word develop, housing estates and units for sale, that question is telling you, it is leading you to somewhere. Where is it leading you, Marianne? Ruth.
Yeah, sectional properties.
Sectional property, very good. Every time you see developing housing estate units for sale, you know that question, those are clues. It's already telling you that this question is leading you to sectional property. Those are the things, how you capture the question. Now, Juhudi does not have all the money for purchase and process to pay down payments of 5 million and pay the rest in installment, but at the same time seeks possession to start constructions and sales immediately. No, so Juhudi does not have all the money to purchase. This question also tells you it may ask you about charges. But let's continue. Ahadi later admits to you that the offer is attractive, but is concerned about the possible default by Juhudi, especially after a friend hinted that Juhudi is not thought to be trusted. Advise ahadi. Question A, on the attendant risk around Juhudi to take possession of the site to commence constructions and commence offline sales of the housing unit to purchasers. So, this person called Juhudi here want to take possession and without having paid. Unaona? And another very, very important fact being introduced here is something called commence a construction and off-plan sales of the housing units. So even if these are sectional properties, this now a question also introduce you to something, a concept called off-plan sales. So you must have the knowledge of what is off-plan sales. And this person this buyer want to take possession without having paid. So you must have knowledge of those two things when you want to answer this question, and it have 2 marks. Can you try? Nani, Marianne, what is the risk?
The is usually in off-plan sales, we have done the sale agreement and payment of, I think, the deposit plus usually an installment or like sales installment plan in the agreement. So you pay upfront because you're delivered the certificate of the one for staying. What is it called? There's that certificate for occupation later. And the completion and the certificate of occupation is given later after the construction is complete. So that's what I remember about this.
Okay. Now, Ruth, say something.
Okay, the attendance risk, what is it?
I'm asking.
No, I'm asking what attendant risk is first.
The risk. Attendant risk is risk.
Oh, it doesn't. Oh, okay.
You know the word attendant. The risk. Giving Juhudi possession of the property he has not paid. Huh? He may pay 5 million and pay the rest in installment. Can you see the question? And he's selling the property. I'm guiding you. He's saying Ahadi is selling it at 20 million.
Okay.
Then Juhudi says that he has 5 million. Unaona? And want to pay the rest in installment. But Ahadi has been told by a friend that Juhudi cannot be trusted. He may default. Unaona? So what are the risks of allowing Juhudi to take possession of the site and commence the off-plan sales, build and commence off-plan sales of the housing units? Having paid only 5 million, 15 million is remaining. What are the risks to Ahadi?
Me, I would just say he made default on the payment or delay on the payment. Even you can start construction, then you stop, so damaging the property, things like that.
Yes.
You can also, if you're going to give me for me to develop. See, now when you come to sectional property, I'll have to change eventually from the master title to sectional property. So I might even end up stealing, taking over your property. And that is how I would argue it.
Okay, you are your last point. Your last point. Master two.
Okay, for me to get now to start construction, and now start selling.
You are Juhudi now. You are Juhudi.
Yes. I'll have to end up starting to change the title, like the title from now a master title to now in unit titles. So in the process, I might end up taking over your changing your property to mine.
Yes.
Yeah, those are the risks because of being somebody who can default.
Yes, very good. I think you have tried your best to answer that question. So these are 2 marks. So you must first of all you must understand what off-plan sales are, because this person you would want to do off-plan sales to the housing units. The question is very clear. So if you are writing this, write this down. First of all, this is a question that has never been tested before in the past. Off-plan is defined as a process through which investors buys into a real estate development before it is completed. The selling and buying of property is done before the property is built, where there are only plans outlining the development concept alongside the relevant project approval. So Juhudi wants to do off-plan sales. So what she will do, she gets possession of land, Ahadi's land, which he has not fully paid. Then he wants to do off-plan sales, which the prospective buyers who want to buy the 40 housing units are going to fund the project. They are just going to be shown the plans and project approvals. So this is the concept of plan. So this man, Juhudi does not have money. He's going to just show the prospective buyers the plans and development concept and development project approvals, which Ruth is saying that he may also take the master title from the Ahadi to change, so to start those processes. So if you now understand what is offsite plans, and you are told that Juhudi has already 5 million, and this land belongs to Ahadi, and the land he gives him 5 million. He has only paid 5 million. He wants to do off plans, and you know off plans what it is. So you say one of the risks of off plans is a risk of off plans is a risk of failure to deliver the developer. In this case, Juhudi would be to investors or buyers. So Juhudi has showed the plans, the concepts, the development plans to would be prospective buyers. They have invested. So someone may say, in this house you want to build, I've given you, for example, because you're making profit, he says maybe one house is going to sell at 2 million. So he makes 80 million so that he can pay Ahadi his 20 million. So the risk of off-plan site is that they show you the plans, but they may not deliver on what they told you, and you have already paid. So The risk there to Ahadi is that there would be buyers or investors who will sue Juhudi, pressing an injunction on any dealings with the Ahadi's property, while Juhudi has not finished purchasing it. So these people may get dispute with Juhudi. They go to court. He did not develop this. They put an injunction to land. Maybe you have not finished with Juhudi. Juhudi has not finished with the Hadi. So this property, putting an injunction on the land. Then another very important point that I think Ruth have said is that it will make Ahadi very difficult to decide the contract and take possession of the property. You remember one of the remedies of the seller is that he can rescind the contract and enter into possession of the property. Since Juhudi would have commenced construction and upfront sales, there is a building there. He has done all those things. Yeah, there are buildings there. You have resigned the contract. You may not enter into possession because already there are buildings there, which have also bid the third parties, which would be third parties. So those are the two risks. You talk about the injunction, pressing any dealings with the land, because these are the risks against Ahadi. Then he cannot also take possession of this land. We go to the next question. Those are two marks. You don't write a lot. Marks guide you how long and how much you should write. When Ahadi expresses his reservation about payment by installment, Juhudi considers taking a loan from a bank Juhudi considers taking a loan from his bank to finance the entire purchase of the land. His challenge is that the bank insists on charging the property under the purchase to secure the loan. Juhudi wonders how then he will manage to sell the individual housing unit to purchasers and transfer title to them while the property is still charged to the bank. Advise Juhudi how this challenge can be surmounted. This person says that he will take the loan. Of course, he has 5 million. He takes the loan of the entire amount. He pays Ahadi, is given the title, but the title is charged. He develops the properties, but he wants to sell each housing units and transfer title to each one of them. But remember, this title is with the bank because okay, it has been charged. There is an encumbrance. So how would this challenge be surmounted? Marianne, what do you think?
I think the question is asking about charges. So I think that when you're creating section, if you talk about after creating the sectional plan, we usually surrender the title we surrender the title to the registry, and then there's the closure of the old register and opening of the new register to reflect the individual sectional properties. And with that, you can, I believe you can apportion charge to each individual unit. So I think they would also mention maybe a professional undertaking to the bank as to the use of the title so that you can open the individual registers and apportion charges to the individual ones, the individual sectional properties.
Very good. That question, you have answered it very good. And that one, it does not need any input. You earn 2 marks. So you say, Juhudi's advocate can issue a professional undertaking to the bank to proceed pending the transfer of property to Juhudi and charging it to the bank. Then, once Juhudi is ready to transfer individual housing units to the purchasers, and after all those process that Marianne have said of changing the to section property, his advocate will do a professional undertaking for the bank to give the title deed to allow subdivision of the land.
I have to ask, a subdivision of the land, or I don't know.
I'm saying, once Juhudi transfer the individual housing units, after doing all those processes that Marianne have said, changing the title to individual titles, do another professional undertaking for the bank to give the title to the land to allow subdivision. You know, this land must be subdivided from mother title to individual housing unit of the 40. We are told they are 40. Then I have a question for you, Marianne. You are saying that these people have, each and every person have bought a housing title, housing unit, and you say that they want to charge the proper, each and every charge is put in the each and every title deed. But remember these people have already paid their nini, and this charge, this loan does not belong to these new buyers. It is belong to Juhudi. Why would they be, as their title have an encumbrance as they have paid in full? I want you to
my understanding was usually, like, if you're the developer, what you do is when you're considering the purchase price per se for each individual unit, you apportion maybe like a part of the charge to each, so that when the buyers, when they're buying, the advocate may be wise enough to demand for the partial discharge, so that in the event you default as the developer, the bank cannot effect like the statutory power of sale against your specific apartment because you had paid your partial discharge. Because eventually, when all of you buy, the developer needs to pay the bank. So it usually works safer if it's a loan of 10 million and you're 40 apartments, meaning almost like every apartment had like 400,000 shillings on each. So if you've paid the complete purchase price, it's almost assumed like the part of the charge that was charged to your apartment has been taken care of. So then you can demand for a partial discharge in the event anything happens in the future.
Okay. Yes, there is a point there. But I will say this, if I was answering this question, the professional undertaking would say that the bank would allow to give the title to allow subdivision of land, and after the selling of individual property, the developer or this man called Juhudi undertake to pay all the outstanding loan proceeds from the said sales. Also, what you are saying, Marianne, is also very Nini. It's not entirely wrong, because you can also apportion each and every individual person this loan, But also, this is another thing. Also, you as a lawyer, you can also take, instead of apportioning individual loan to each and every buyer, you can undertake and tell the bank to release the title and undertake if you do the sales, you can you are going to pay the outstanding loan, so that each and every person who buys get a clean title without any encumbrances. A professional undertaking is a very, very, very powerful thing, if you didn't know. It beats the advocate. So in that question, if you talk about professional undertaking, and that what you are that question you have answered. Now, point C, discuss two possible options to Juhudi in structuring the sale of the units homeowners, buyers, noting to bring out merits and merits of the options. So, structuring the sale of units to homeowners to bring out the merits options. Possible option available to Juhudi in structuring the sale of the units to homeowners, noting to bring out the merits and the merits of their own, of every. So, Marianne, you can try.
I'm not sure, but I would think of either an outright. Okay, I think my answer is wrong, because I was thinking of long-term lease and sale under the Professional Properties Act.
Ruth?
Now, what I know about long-term lease, that one it's being removed.
Sorry?
Most of the long terms are being converted to sectional properties.
Yes. What do you understand by the word?
I'm not even understanding the question.
What do you understand by the word? The key word here is structuring the sale of the units. Structuring the sale of the units. What is the meaning there?
If I'm going to sell it or I'm going to lease it.
You know, the word already is sale of the units. Remember these people, this person has developed the 40 housing units. Remember the question what was saying? He wants to develop 40 housing units. Housing units for sale. And now you want to sell them, structuring the sale of units, nothing to bring out the merits and demerits. Option available to Juhudi is structuring the sale of units, structuring the sale of units to homeowners. Structuring the sale. Those are the keyword. Structuring the sale. Okay, this is how I understand. This is how I understand this question. I understood this question to mean that Juhudi have already constructed the 40 houses, and he want to sell them to the homeowners and buyers. And what is the best method of selling them? This is how I understood the question. Which is the best method of selling these these sales? So I said Juhudi can use two models of selling these units. He can use a real estate agent, or he can use himself. He can use himself. He can either use the real estate agent, or he can use himself. That's how I interpreted the question. And to bring out merits and demerits of the each and every way. So I said here, the agent will reach the homes, market them, coordinate them, showing them with agents and potential buyers. This will also help you evaluate offers. The estate agent will help you in getting offers, negotiating, and ensuring the deals go through. They may also attend closing appointment with the developer. You know, this real estate, what they do on your behalf. They do all the things on your behalf. Real estate may operate on a commission fee. Of course, they operate on a commission fee. You know, real estate. They do all those things, negotiate, they market, they do things, they do this on a commission. So you are defining the real estate agent. What are the merits of having a real estate agent? They help you throughout the process if you are new. They help you their access agent marketing tools and listing services, Facebook, website, even if because they are experienced. They assist you in negotiation and contract signing. Those are merits. You are still discussing merits. Let's work on your part. You don't go looking for the buyers or the developers. This would be the buyers. So what are the demerits or disadvantages of using a real estate agent? You pay the commission. Then the other thing was selling the new house, the off plans and all those things. The advantage of doing it yourself as a developer with Juhudi is that you have total control over the pricing, marketing. No commission to agents. The disadvantage are, of course, you don't have access to marketing tools, which the real estate agent may have. Because they are established. Then you may get longer to get the would-be or sell to buyers because you don't have involvement of agents. So that is the disadvantage. Higher. We go to the next question. Ahadi is considering the possibility of purchasing 2 houses from Juhudi under the separate agreements, but he has heard that off-plan sales are risky. Advise Ahadi on the risk of off-plan sales. So Ahadi, remember this is the person who was selling Juhudi the property, but now he wants to buy some houses from Juhudi under the separate agreement. But he's told, advise the off-plan sales are risky. So remember in our question A here, we defined what are off-plans sales. Is that where you are as the owner, you are shown the plans, the development concept and project approvals. Then you pay. Then the house is after you pay, then the house is built. You pay upfront. So what are the risks to a hardy, to the would-be buyer on off-sale plans? Risks, Marianne.
The risk, of course, are failure for the developer to deliver.
Okay, good. Ruth, that is 1 point. There are 2 points here, 2 marks.
You might not have a control on the design, like the quality.
Yeah, you may not control. Very good. You may not. They may show you plans, they may, but not deliver on quality. So, another point is that, of course, building on what Ruth have said is that the completed property may not be per the buyer's expectations. The material used in finishing or in building may be on inferior quality. You can build on that point. Then, another point is that the completed property may not be per buyer's expectation. Or that one I've said. Then developers insolvency. You may pay the developer and he may not apply the money to what you have said. So he become insolvent and not doing the projects. Not, or can also say that they don't follow the timelines and agreed on the off plans, the buying concept, the approvals. And that is it. We have done question 1 and 2. We have 3 minutes to go. And we are going to continue in the afternoon. We are going to go very slow. There is no rushing. Where we are going to reach, we are going to continue maybe maybe tomorrow or Monday. We go very slowly. There is no, I want you to get, I said even if it is one person, provided is one person, I'm ready to proceed. It's not about numbers, it's about quality. And I have put that in my terms on conditions for doing the timetable. There's one person who was saying that he want to pay if the question, the class is going on, he want to join, but he has not paid. So he will join us in the other question, in the other at 6. I usually put 2 hours because you talk a lot. You know, you also need to breathe and re-energize. So before we call it a day, we finish for now. Ruth, do you have anything to say?
What I would say, I have benefited a lot, especially with the processes. So I am grateful. To a point, I want to ask if you have the procedure of conversions, maybe from a long-term lease to a sectional property, because I've understood your way.
Okay.
Yes, but I appreciate. I've learned a lot.
So we that one long term lease to sectional. That one we will do it at 6. Before we start the question. Remember. You cannot fix ourselves. We cannot fix our eyes only on the question. There are other things they may come up on when you are dealing with the questions. So long-term lease, conversion to sectional property. We are going to deal with it in the afternoon before we start. Logged on time. Then, Marianne, you have anything to say?
No, I'm good.
Okay, you are good. You are good, eh? Sawa sawa.
Yes.
Sawa sawa. So let's meet at that time, and we are going to continue. Thank you very much.
Thank you.